Okay, I think we're going to kick it off now. Good afternoon and welcome to our Cybersecurity Awareness Month webinar, the NYDFS Cybersecurity Regulation. What do the proposed changes and increased enforcement mean for covered entities? I'm Jeff Taft. I'm a partner in the Financial Services Regulatory and Enforcement Group and the Cybersecurity and Data Privacy Group. So I have a particular interest in this topic, and it's at the intersection of where I practice. Joining me today is Dominique Shelton-Lepsig, also a partner in our cybersecurity and data security practice. She leads our global data innovation team and advises senior leadership, corporate boards, and audit committees regarding risk identification and mitigation in the areas of privacy and cyber. During today's webinar, we'll be delving into the NYDFS's proposed changes to their cybersecurity regulation, and in particular, what these developments mean for covered entities, their C-suites, and their boards. We hope to have some time at the end to answer questions from the audience. You'll see a Q&A button at the bottom of your screen. We'll be watching those for your questions, so please use that function to submit questions to us, and we'll try to answer them at the end of the program. And with that, let's begin. Next slide. The NYDFS cybersecurity requirements have become a model for other regulators since they were promulgated in 2017, because they are detailed and very risk-focused. For those in the insurance industry, you've seen this framework replicated by the NAIC, and those in the non-bank financial services companies have seen this framework replicated most recently by the FTC and their revised GLBA safeguarding rules, which become effective later this year. On July 29th, 2022, the NYDFS issued a pre-proposal outreach containing revisions to their rule, which they would hopefully finalize in a proposal later this year. The proposal is extensive and would significantly expand the requirements for covered entities. Comments on the pre-proposal were due by August 18th, and we're expected again to see a rule later this year that will include some of those comments. Some of these requirements will be technical and operational and require changes to systems. Access controls and inventory and asset inventories are just two examples of that. This will require two of the more scarce resources for every company, time and money. We'll highlight some of the proposed changes by walking through the various sections of the proposed rule. So let's start with the definitions. I think one of the key definitions, obviously, is they're creating a tiered classification for the first time. There will be some companies, Class A companies, for example, that will have higher obligations than the average company who is subject to the regulations. And there will be requirements in the proposed rule that apply only to Class A companies. As you can see by the definition, a Class A company is a fairly large company, given the fact that it's $1 billion in average gross annual revenues over 3 years. And it includes affiliate revenue, but still that's a very large measurement. So that's going to exclude a lot of your traditional smaller types of companies, but capture some of the largest banks and insurance companies and others. As discussed, these enhanced requirements for the Class A companies will include annual audits of their cyber program, third-party risk assessments every 3 years, a password vaulting solution for privileged accounts, and endpoint detection and response solutions must be implemented. Also, there's an expanded definition of risk assessment. I think that's important because obviously a risk assessment, as we all know, is the linchpin of the NYDFS cybersecurity rule. A risk assessment is important. It must be tailored to a particular company. It must identify particular risks that that company is facing. And obviously the NYDFS is going back and kind of taking that definition and recrafting it a little bit just to make sure that people are in fact conducting what they believe to be a risk assessment. There are a number of other definitions, including independent audit, privileged account, and senior governing body. We'll kind of cover those as we go through the particular sections where they come up. Next slide. So starting off with the cybersecurity program, I think this is key because this is one of the first requirements for the Class A companies. They have to conduct an independent audit of their cybersecurity system, at least their cybersecurity program, at least annually. An independent audit obviously can be conducted by internal auditors or external auditors. I think for large financial services companies such as banks who have a fairly robust internal audit group, that's something that they could obviously take on themselves and handle it, while others may be referring that type of an audit out to a third party who would come in and perform that function. Also, on the cybersecurity program, the NYDFS requires that each institution who has a part of its program maintained by an affiliate make that part of the program available to the NYDFS. This is very similar to the guidance that the NYDFS issued last October of 2021, where they basically said that you could rely on an affiliate cybersecurity program, but in doing so, you obviously had to make that program and those things available to the NYDFS from an examination purpose. One example of the type of program that might be shared would be shared services or something between the two entities or between a U.S. branch of a foreign bank, and the foreign bank may share services and the like, and that may obviously trigger some supervision and examination of the foreign entity to the extent they're relying on that for its cybersecurity program. Next slide. Penetration testing and vulnerability assessments, obviously a key part of the NYDFS regulation. These are both being expanded. One of the things that's new here is that the penetration testing is supposed to be done by an independent party. I think that's something that was done by a lot of third parties anyways, but that's something that's now being included in the rule itself. It must be conducted on an annual basis. Also, that's something, and vulnerability assessments must be conducted regularly instead of at least biannually. So obviously, I think the DFS is trying to get to a point where the vulnerability assessments are being conducted more regularly, and certainly based upon events that might trigger concerns around vulnerability assessments, whether that's a breach or some other security incident. Class A companies, again, have their own requirements here. They need to conduct systematic scans or reviews for vulnerabilities at least weekly. Again, I think this highlights that Class A companies are going to be held to a different standard than the other companies as part of this. All institutions will need to manage material gaps that have been identified through the testing, and these gaps must be reported to the senior governing body and senior management. This obligation to report up is new, and as Dominique will discuss, one of the areas requiring more oversight in the cybersecurity programs under the proposed rule. Access privileges. Access privileges are obviously another important area. This is going to expand access privilege requirements to more fully implement some of the requirements, especially with respect to privileged accounts and privileged and restricted access for remote devices. That's obviously an important aspect of the program. Privileged accounts are broadly defined to include a number of what we would consider to be kind of operational accounts or technical accounts that could be by security personnel who would have access to a broader range of accounts. These accounts, because of their access to other accounts, have the ability to basically, if they are breached, to trigger wide-scale interruptions, or they could trigger wide-scale unauthorized access to a host of different information. So obviously, DFS is trying to impose some additional requirements around privileged accounts. The concept has been added, obviously, to address these concerns and the significant concerns presented by these types of accounts, and to subject them to heightened scrutiny and oversight and protections. Institutions will need to implement secure password rules, and Class A companies will need to implement additional controls over privileged accounts. These controls can include, monitoring access, password vaulting, and also automated methods of blocking common passwords. So words such as password could not be used as a password and other things like that. And that would have to be automated into the privilege controls. Next slide. Application security, risk assessments. As I said, the risk assessment obviously is a key part of any cybersecurity program, and especially under the DFS, because it is the risk assessment that triggers all of your other requirements under the rule. The CISO must review security materials applicable at least annually instead of periodically. Again, DFS looking for more hands-on approaches from the CISO, as well as Dominique will talk about the board and others. This periodic review, which was in the prior rule, I think is something that they initially thought would be sufficient, and now I think they're really wanting to have a much more hands-on regular approach. With respect to risk assessments, the new proposal would require all institutions to update them at least annually and conduct an impact assessment whenever a change in business or technology causes a material change to cyber risk. This could come about when you have any sort of merger or acquisition, or any new lines of business are created, or new operating systems are used. All of these changes could trigger some need to do conduct an impact assessment of the new line of business or of the new systems, and even could require you to update your risk assessment within the course of a year, basically to address these new risks that are presented. Class A companies, again, would be required to use external experts to conduct a risk assessment at least once every 3 years. So obviously for 2 or 3 years, they could conduct their own, but for every other third year, they would have to bring in a third party to conduct that risk assessment. So I think that's obviously something that's new. Doesn't apply to everybody, it just applies to the Class A companies, but it's just a further delineation that these larger companies present some greater risks, and that they need to have some more stringent requirements. And some of those stringent requirements will include obviously bringing in third parties to validate what in fact they've been doing. Next slide. Okay, so now getting into some of the other things: third-party service providers, multi-factor authentication, and data retention, obviously all key parts of the existing rule. One of the things that they're removing here is they're removing an exception that an agent, employee, or representative or designee of a financial institution or covered entity, that is, that it itself is regulated by the NYDFS, does not need to have its own information security policy if it follows the policy of the principal institution. This was an exception that a lot of insurance companies and individuals who are either insurance agents or other sort of a licensed person by the DFS, they were relying oftentimes on their employer or their insurance company for which they served, either as an independent or exclusive agent for. So this requirement now that they will need to have their own third-party security policy in place. They can't just rely upon the institution of whom they're doing their work for. I think obviously there was some concern that implementing that institution's policy might not be enough to address some of the concerns that might be raised by their own information security. Having their own systems, having their own computers, having their own offices and things of that nature obviously presented some of the risks that I think that the DFS was concerned about. So again, that's an exception that's been removed, and I think that's going to have an impact obviously within the insurance industry, and it may have a broader impact within some of the other areas, mortgage brokers or folks like that as well, who are relying on maybe companies who they were brokering mortgage loans for. Also, the requiring the use of multi-factor authentication for remote access to any systems for which non-public information is accessible. Under the old rule, you didn't necessarily have to rely on MFA if your CISO basically said that you had in place and gave you a designation, a written designation that you had in place, reasonably equivalent security. Multi-factor authentication was not required at that point. That is no longer possible. So if you were relying on basically the CISO designating your system as having reasonably equivalent security as to MFA, you're not going to be able to do that, assuming the proposed rule continues that distinction. That's obviously consistent, I think, with how the NYDFS has been looking at multi-factor authentication. The DFS obviously views multi-factor authentication as an important way of stopping security breaches. A number of security breaches they've identified have resulted from either the failure to implement multi-factor authentication or weak multi-factor authentication. So it's not surprising that they're going and imposing a more stringent requirement around multi-factor authentication. Requiring multi-factor authentication for privileged accounts, again, is very consistent with that, I think. Consistent with the view that these privileged accounts contain additional access rights and additional ability to access NPI and other important information. So having those have multi-factor authentication obviously is important. In addition to removing the language regarding the ability to waive, the CISO to waive multi-factor authentication in some cases, the DFS is also saying now, for purposes of the possession factor and multi-factor authentication, you cannot include text messages to a mobile phone as a means of demonstrating the possession factor. This is something that's been getting a lot of coverage. I think the NYDFS has been one of a number of agencies who's basically said that they don't necessarily view that as a secure method. Obviously, once you lose your phone, then somebody could easily go and take advantage of that and open credit or open bank accounts or something in your name, relying on that factor in multi-factor authentication. I think one of the interesting things about this is that in the FTC safeguarding rule, which again becomes effective in December, there's been a lot of question around that, whether text messaging and SMS messaging would be sufficient for possession factor in multi-factor authentication. In the rules definition of multi-factor authentication, they do not, in fact, list SMS or text messaging as a way of demonstrating possession. However, when you go and look at the preamble, there's an ability in the preamble to rely on it in certain instances, but the FTC did not want to greenlight it as being in a way that was appropriate in all indications. I think, though, the NYDFS basically saying that it's no longer, in their view, an effective way of using validating possession in multi-factor authentication, it's probably going to have an impact that less and less people are going to rely on that factor. Obviously, even if it satisfies the FTC safeguarding rule, but it doesn't satisfy the DFS regulation, for entities who are subject to both rules and subject to both sets of supervision, for example, that would include, mortgage brokers and folks of that nature, sales finance companies and others who are licensed in New York, but also treated as financial institutions. They wouldn't be able to rely on it from the DFS perspective. So it's unlikely that they're going to want to continue to rely on it from the FTC perspective. So I think that's an important aspect to keep in mind when you're thinking about multi-factor authentication and what will satisfy the requirements. So limitation, obviously, in the rule on data retention. Data retention includes a requirement that institutions maintain an asset inventory of all hardware, software, and outsourced technology resources. There have been a number of stories recently involving some financial institutions who, in the course of decommissioning some of their computers and some of their other technology, had a number of bits of personal information still maintained on those computers that they were selling into the secondary market. The SEC and others have taken action against companies for this. This is very similar to what we saw maybe 10 years ago with Xerox machines and people forgetting on the Xerox machines that there was a record of everything that had been Xeroxed. So I think what the DFS is obviously getting at here is they want people to basically understand their technology, what they have for technology, but what also that technology is holding as far as personal information, classifying the data on that personal information. So I think that's an important aspect. Next slide. Training and monitoring. I think obviously training has become an important aspect of cybersecurity programs. I don't think you can have a robust cybersecurity program without training employees and hiring the right employees. I think we all know that. I think we would all potentially identify third-party vendors and employees as potential weak points in our cybersecurity. And again, that's why training is so important. It also recognizes the fact that while phishing and other types of training are important, it's better to have in place protections such that some of these emails are blocked before they even get to authorized users. So in other words, before having them get to the authorized users who identify them as phishing expeditions or things of that nature, they're blocked, by the system, in fact, and they're not something that is transmitted on. So I think it's important, obviously, to provide training exercise simulations on cybersecurity. The cybersecurity training obviously has to involve the right people. I think obviously the right people involve senior management. In some cases, it's going to involve the CEO, but that's important that everybody gets trained on important things and that these things are being implemented. Simply having policies and not implementing them obviously is not a cybersecurity program. It is indicative of there being potential weaknesses in the program. From the Class A company perspective, there's an additional requirement here. I think I highlighted it in the beginning. That's endpoint detection, so that you can monitor anomalous activities. You can centrally log that activity, and there's security event alerting that will happen. Obviously, the CISO in those organizations has the ability to determine in writing that they have reasonably equivalent or more secure controls in place. I will say that the DFS tends to look at those types of certifications very carefully, and they want them to be updated on a regular basis. If that's what the CISO has determined, they want that to be done at least annually, and they want there to be a reasonable basis upon which that reasonable equivalent security determination has been made. Also would highlight here that this is, again, a technical requirement for the Class A companies, but it's obviously going to require time to implement it. This is one of these areas where, you know, some of the requirements that are going to come out of this proposal and the finalization of this proposal are going to involve technical changes, as I said at the outset. Those technical changes aren't simply just updating policies and procedures, but they're actually putting in place requirements. As we'll discuss in the end, there's certainly some additional time that you'll have to implement some of these things, and this is one of the ones that will have a longer time frame in order to address that. Next slide, please. So here we're talking about encryption of non-public information and incident response plans. Obviously, incident response plans are significant. Requiring institutions to maintain written encryption policies are also important. Encryption is becoming pretty much standard, state of the art. The FTC's safeguarding rule also requires encryption. If you're not using encryption, obviously you have to have some compensating controls. Those compensating controls obviously have to be identified by the CISO. So I think that's obviously, again, an important area for one. Incident response plans obviously have always been important from the NYDFS perspective. I think the proposal, though, heightens what the DFS is now focusing on, which are business continuity and disaster recovery planning. While the business continuity and disaster recovery plan was always part of a cybersecurity program, and it was always identified as one of the policies and procedures, the DFS has now gone into, I think, pretty great lengths as to what's expected from a BCDR plan, not just simply saying that you have it, but really starting to get more granular about what needs to be in the plan. I think this is somewhat indicative of the proposed rule in and of itself, in the sense that a number of things that the NYDFS, I think, left less prescriptive in the original rule, they're now coming back and circling back around, saying that there needs to be some more formalization and some more prescriptive requirements around that. I think the business continuity plan is one of them. And I think obviously that the fact that they're mentioning it specifically, I think, tells you how important they think it is. It obviously should be working hand in hand with your incident response plan, even though they're separate plans. The business continuity plan also has a way of highlighting, or is being highlighted, I think, by a number of what I would call disruptive events, such as ransomware, where business continuity plans may not have contemplated something of that nature. Business continuity plans, I think, historically have focused on maybe some of the more types of natural disasters or things of that nature, where ransomware and some other things like that. And now the prevalent type of disruptions that we're seeing in this. So that's why I think the NYDFS is particularly focused on that. Obviously, they've been focused on ransomware in particular. They put out a lot of guidance around ransomware, and recovery and workarounds for ransomware are obviously very important to the DFS. From an incident response plan, I think testing is important. They've gotten more prescriptive with respect to testing. While they haven't necessarily said everybody who has to be at the testing, they have indicated, for example, in the proposed rule, that the CEO and senior management should take part in incident response testing. I think that's important. I mean, it's getting buy-in from top leadership, making sure that everybody who needs to be involved is involved in that. So I think that's obviously something that the DFS thinks is very important. On the business continuity testing, obviously they want you to test the business continuity plan. That should include senior management. It doesn't say the CEO, but it says senior management and all of those who would be responsible for implementing that. So I think that's also very important. Institutions should also periodically, test their ability to restore their systems from backups and maintain backups. Again, this goes really directly to some of the things that have happened with ransomware. People have been hit with ransomware and had the inability to draw information up from their backup systems because they hadn't tested those systems. Those backup systems need to be isolated from the network so that they're not also impacted if there's ransomware. But again, I think these things are highlighting with incident response plan and business continuity, disaster recovery plans, the importance of involving the right people within the organization, the right people being senior leadership, obviously, but also others. And Dominique, obviously, feel free to weigh in. But I think this is just another indication of why the DFS wants buy-in from the top, both from senior management, but also from the board. So.
And I mean, just to feather in on what you're saying, Jeff, I think that's so important. And I think there's a realization with New York DFS, as well as other regulators, frankly, that it will be the C-level and board that will ultimately be accountable if there is a disastrous data breach, ransomware involving a financial institution. Those are the ones that will need to be testifying before Congress or elsewhere. So incorporating them into the incident response is, although didactic in this draft rule, is in keeping with what's actually the reality.
Yeah, I think the DFS obviously is trying to get, much like they do on the banking and on the insurance side, they're trying to develop a culture of compliance, and that culture of compliance obviously starts from the top, whether it's the board or senior management, and trickles its way down. Obviously, cybersecurity is no different, really, when it comes to any other type of compliance program that any other financial services firm has. There needs to be buy-in at all levels of the organization. Next slide. Okay, so now we're to notices to the superintendent. So basically there are two types of notices, I think, as everybody knows. There's the annual notice that everybody files, and then there's the cybersecurity event notice that people loathe to file, but some have to file, obviously. I think it's important because the DFS is making some significant changes to these types of notices and the circumstances in which these notices are provided. I guess I'll start with the cybersecurity event notice, because obviously that's an important one. Obviously, for cybersecurity events, as you all know, there's a 72-hour notification period to notify the DFS of any cybersecurity event or a reportable cybersecurity event. I think we've seen a lot of clients struggle with, when to make that notice, when to provide that notice. I think what the DFS is saying here, and they're really not providing anything new, except they're trying to provide a couple of additional circumstances under where notice may be required. And there are two specific notification obligations and events that they've highlighted in the proposed regulation. The first is when somebody gains access to privileged accounts. So again, we're back to privileged accounts, which is a new concept in this proposed rule, but recognizing the importance of privileged accounts, we understand why the DFS is looking for notification of access to privileged accounts, knowing that they would likely lead to some sort of broadened, perhaps cybersecurity event or access to NPI of information of customers, or even confidential, information of the company itself. The second event, again, and this is consistent, I think, with what the DFS has been focusing on the last few years, is any event that results in the deployment of ransomware with a material part of the institution's information systems. So obviously they're trying to capture, ransomware that has a material impact on the operations of the company, the operations of its information system. Again, I think this is very consistent with the guidance the DFS has put out on ransomware, both under the cybersecurity rule, but also for some of its regulated entities. So I think that's obviously something that people need to keep in mind. These are changes obviously people will need to make to their policies to just ensure that these circumstances are captured. I think that they're important ones to capture because obviously the DFS is super focused on them. So there's also an added notification requirement for extortion payments. Again, going hand in hand with ransomware. I think of extortion payments being largely for ransomware, so I think that's an important aspect. You'll be required to notify the DFS if any extortion payment is made in connection with a ransomware cybersecurity event. You'll have to notify the DFS within 24 hours of making that payment. So that's pretty much, as soon as you know you're going to make the payment, you should be prepared to notify the DFS. The DFS also has a follow-along notification requirement, which I think is also very important. Knowing that if you're going to pay the ransom, you're going to have to provide the DFS with notice within 30 days of the reason why the payment was necessary, and a bunch of other, information about that payment, consideration of alternatives, What diligence did you perform? How did you get comfortable with the fact that the person who you were paying wasn't somebody who was a prohibited person on the OFAC list? All of the things that you went through as an enterprise or as an organization in order to get comfortable with making that payment. Now, a lot of those things are things you're going to be doing based upon the FinCEN guidance or the OFAC guidance that's obviously out there when it comes to making ransomware payments. But now you're going to be reporting that to the DFS, so you're going to be letting them know, in fact, that this is what we did. Like every notification, you're going to be opening yourself up to, potentially after the fact, second guessing, was it really necessary? Were there alternatives to making the payment? A lot of the things that you'd be going through and discussing internally now may become discussions you're going to be having with one of your regulators. So that may be not a foreign concept for insurance companies or for banks, who obviously are highly regulated entities and oftentimes would have these types of discussions. But I mean, for other companies who are covered entities for purposes of the DFS, but may not be subject to the same degree of day-to-day supervision and regulation, this could be certainly a significant change. So I think it's just important, again, given that the DFS has been laser focused on ransomware and the payment of ransom payments to third parties, it's just important to keep in mind that there are these two additional obligations. The last point on the slide, I think, is also very important. And this goes to the annual notifications that everybody makes. I guess they're April 15th now. They have now dovetailed with tax day, I guess, so everybody can remember how painful it can be. But so what's happening now is they're basically allowing you, after what are effectively 5 years of having to certify or not certify compliance. Now the DFS has decided that they're going to allow people to make certifications when they're in less than full compliance with the cybersecurity regulation. This is totally different than how it is today under the existing regime. Under the existing regime, you can only certify that you're in compliance or you can't certify. This is kind of the in-between ground that I think a lot of people were looking for. I don't think it's necessarily a panacea, though, for companies that aren't in compliance, because effectively what you're doing at this point is you're notifying the DFS that, in fact, you are not in compliance with the cybersecurity regulation. And you're going to basically give them, as part of this, a roadmap to how you're going to become compliant and the time frame effectively for you to become compliant with the cybersecurity regulation. So it may seem like an initial get out of jail free card, but I have a feeling it's going to subject you to some intense scrutiny, some intense monitoring. And I would expect that the DFS is going to be checking in on people to see what type of progress they're making. This doesn't strike me that the DFS is going to allow people to continuously certify year in and year out that they're not in compliance with particular requirements. I would imagine this would be for instances where there's something that's been detected or there's a technical fix that hasn't been made because there's some software or some issue around implementing that requirement. I don't think this is going to be a place where the DFS is going to be particularly happy if you're certifying that you're not compliant because you don't have policies and procedures that address something. I think those are the types of things that the DFS really isn't expecting to see here. I think they're expecting to see technical requirements that can't be met. And I think that's why it's important. The second thing about the certification that's changing, again, the DFS initially was they were not very prescriptive necessarily about who needed to sign the certification. It was supposed to be a senior management official. Some folks, thought it could be the CISO. Some people thought it had to be the CEO. Some people bumped it up to the board because they thought that was the appropriate level. Now the DFS has gotten relatively prescriptive in this regard, saying that the certification should be made by the CEO and the CISO. So it's both of them who are making the certification of compliance with the cybersecurity regulation. I think the DFS has always thought that the compliance and the certification of compliance was one of those things that would help ensure that people were in fact complying, making some accountability around this provision. Obviously, now that you have the CEO and the CISO who are responsible for certifying, that puts some additional pressure on them. In large institutions, I mean, obviously what we see is people are oftentimes maybe sub-certifying And then ultimately the CEO and the CISO might be relying upon those certifications of others. In a large organization, it's unlikely that either one of those individuals is going to have firsthand knowledge about everything that they're certifying to, obviously. So that's why tends to be sometimes some sort of sub-certification. For organizations that do not have CISOs, you can have the officer, the senior officer who's responsible for cybersecurity, who's been designated as the person performing the role of the CISO, that is, make that certification. I think one of the interesting things is you have a number of companies out there, especially on the smaller side, who may not have full-time CISOs. They have part-time CISOs or rent a CISO. It's not clear to me how willing, able that those individuals are going to be to make such a certification, or whether in an organization or an enterprise like that, that certification would in fact be made by somebody who's an officer of the company, rather than somebody who's performing as a part-time CISO. But I think that's an important thing to keep in mind. I think that's something that's going to be enhanced accountability. I think that maybe the CEO also may want to have additional certifications and sub-certifications if they know now they're going to have to make that. So I would expect a lot of companies, when this becomes implemented, they're going to go back and look at the process they go through in order to make that certification, and kind of revisit that, given the fact that the CEO is going to be somebody who is basically making it. So again, it's another instance and another occurrence within the regulation of accountability being imposed on particular officers, particular individuals within the corporation, that again is designed to increase accountability and compliance with the regulation. Next slide, please. So exemptions and enforcement. They are proposing some changes to the exemptions, basically broadening them or widening them a little bit. So they're bumping up the personnel threshold from 10 to 20. They're bumping up the total assets threshold from 10 million to 15 million. I think those are obviously, trying to keep up with what's a small business these days and what's a small business considered. I don't think those are significant changes, really, and I don't think they're going to have the effect of really carving out a whole bunch of new institutions. I think it's basically going to allow some smaller institutions perhaps to maintain their existing exemptions for a longer period of time. Those exemptions might have otherwise gone away or been phased out, given the fact that the 10 employees or the $10 million thresholds were something that they might have been approaching after being in business for a few years. So I think that's something, obviously, that's important to keep in mind. The other thing I would say about the exemptions, because it comes up every single year, they're not self-effectuating. You need to file for an exemption if you have an exemption, and you're supposed to file within a short period of time after basically being entitled to declare that exemption. You don't want to be filing the exemption the week before you're filing your certification, so that you can certify to a limited number of requirements. I really think if you're claiming an exemption, you have to claim that exemption early on, or risk the question of the DFS looking at that and wondering why you in fact didn't declare it. And if you don't declare it, you really don't have an exemption. So when you go to certify, the DFS is going to wonder why you're not certifying to the entire regulation, rather than those limited parts you might have to as an exempt entity. On the enforcement front, nobody wants to hear this, but the DFS has thrown out some clarifying information in the regulation. The first thing is they're clarifying basically that one violation is a violation of the act. So a single act of non-notification or something of that nature is in fact a violation of the regulation. There's no de minimis exception or anything like that. So one failure to notify is a violation of the act. Obviously, a violation of the act may preclude you from certifying compliance with the act on an annual basis. So keep that in mind. The DFS has also listed 15 factors they are going to consider when they take an enforcement action for non-compliance. These 15 factors are already in the banking laws, so I think the banks and other financial services companies may be familiar with some of these. They look at things like a cooperation, good faith, prior history of violations. Was this something that had been cited in a prior examination? is this an isolated incident or part of a larger pattern or practice of non-compliance? So I think those are some of the things they're going to take into account when imposing penalties on institutions who are in non-compliance with the regulation. Just one quick thing I also wanted to mention. Now we've kind of gone our way through the changes. How the proposals would be phased in. Obviously, there needs to be a proposed rule, and that proposed rule needs to be a final rule. But once the final rule is published in the state register, basically the provisions of that proposal would become effective within 180 days, unless otherwise indicated in the regulation. For purposes of the pre-proposal regulation, there's a 30-day period for the new cybersecurity notification requirements. So that's ransomware, that would be subject to a 30-day implementation period. That wouldn't be subject to the longer 180-day period. For some of the more technical things, such as access privileges, MFA, and implementation of endpoint protection by Class A companies, they would get a year for that to get that implemented. So again, the 180 days, that would be for everything else at that point. And that would include, inventory assessments and conducting an asset inventory. So if that's something you haven't done, you may want to think about starting that already, because 180 days may not give you a lot of time once the rule becomes final to do that. So let me skip quickly to the enforcement actions. And again, I'm just going to go through these quickly and then let Dominique come and talk a little bit about governance. There's not too much I want to spend on the particular actions. I think all the actions kind of speak for themselves. We've listed 3 of the more recent ones. I would say this: they highlight the increased enforcement by the DFS. I think there was a long honeymoon period with the DFS. I think in some ways didn't really make public enforcement actions. There were some private examination findings that they asked people to correct, but there really weren't a lot of public enforcement actions, except for where they found things to be particularly egregious. I think the things we're seeing there are particularly failing to report cybersecurity events as a common concern. And, obviously it's easy for the DFS to say in hindsight, you should have given notice. Failure to provide the notices, obviously, and similar non-compliance means that if you filed the certification, it's likely that you provided a false certification about compliance with the rule. So that's also something to consider. Again, I think this particular enforcement action really was a cyber breach that went unreported. Next slide. I think this is also, again, another example of a breach, and then the underlying cause of the breach was non-compliance with the MFA requirements. Also, failure to certify properly because you certified and you weren't compliant with the MFA requirements. Again, they tend to pile upon each other. So one violation can lead to another violation, then a certification violation also can follow. The last one I just wanted to mention was the Robinhood crypto one. I think this is important because it also talks about adequate accountability for cyber programs. That means accountability both at the board level and for ensuring that management is responsible. And with that, I want to turn it over to Dominique, because I think she's got a lot of good things and some good insights here from some of her other work as well. So Dominique, why don't you take it away and you can cut off the Jeff Taft monologue.
Well, this is great. Thank you so much, Jeff. And we can go to the next slide. When you talked about accountability, that really is something and a flavor that we see in these New York DFS proposed rules and updates that came out on July 29th. So first, this idea of the board or the CEO approving the cybersecurity policies, and that's in section 500.3. And I thought it was really interesting in that section where they lay out what the cybersecurity policies are supposed to include. And there's really like 15 areas, everything ranging from incident response that you mentioned, data governance, access controls, and then customer data privacy. So just understanding the breadth that they are expecting the board or the CEO to approve. Let's go to the next slide. The other thing I thought was very interesting is this idea of getting the reporting, the regular annual reporting about the state of the compliance program, and just piggybacking off of what Jeff was talking about in terms of accountability, both in the enforcement side as well as throughout other parts of the regulation, this idea that the Chief Information Security Officer will be coming before the board and making and senior leadership and making a report as to the status of compliance, and understanding that that report must be understood by the board. In 500.4D, it discusses this, that the board should either understand it or make sure that they are getting the proper advice so that they can understand the reporting. We can go to the next slide. I just want to sort of drill down on this issue. There's also further requirements on the CISO, that there's an understanding that the CISO would need to interface with the institution's senior governing body and to ensure that there's appropriate oversight over the cyber program. And let's go to the next slide. Just honing in on this just a little bit. The understanding is that the board should be conducting themselves in an informed way and not just simply a receptacle for CISO reporting. And so what I want to talk about here is the need for the reports to be contextualized, that they are providing the update, but also giving the board the ability to intelligently interact with the information. And if the board does not have the requisite expertise within the board, and I will just point this out, with the 15 areas that are covered in the cybersecurity policies and the reporting at 500.3, we have a cyber group of 100 attorneys, partners, and associates, and we would be hard pressed to see one person have all of those 15 areas between customer privacy, access controls, technical controls, incident response, disaster relief, et cetera. Usually those are verticals that maybe 2 or 3 we would master. Maybe, Jeff has 10, but yeah, all 15 is a lot to ask, and especially from your board that might be comprised of former chief marketing officers, CFOs, et cetera. The ability for them to be as granular as this didactic rule is calling for is questionable. And so the rule does also say if the board does not have that capacity, and I would argue just a point of opinion that it might be good belt and suspenders to consider having the third-party advisor advising the board, even if there's one individual with some cyber experience. But given the breadth of the areas, putting all of that responsibility on that one board member is a lot. Now, I'm going to pause here to just maybe move to the next slide, and maybe we open it to questions. I did see quite a number of questions come through. And so, Jeff, while you were presenting, there were a couple of questions in here. I think we have a little time to go through them. Somebody asked, what does it mean to make available to New York DFS the relevant and applicable provisions of a program? And I think we can take the deck down now because we're just going to get into the nitty-gritty. Shelley, thanks. Jeff, any thoughts there?
I think that's a good question. So this comes up a lot in the affiliate context. If I'm relying on one of my affiliates programs, what do I really have to make available to the DFS? Do I have to provide their vulnerability, their pen testing, and all of that other information if my information is basically on their system and being protected by them? I think the DFS obviously, has a broad view of what that means. I think they want to be able to evaluate your cybersecurity program as if it were your own, and anything that you are relying on a third party for, I think they would take the view that they would need to see that third party's performance of that element in order for them to evaluate your compliance. So if the third party is holding information, you're saying that information is encrypted on their system, I would think that the NYDFS would have to see or have some indication that information was in fact encrypted while it was held by that third party. And this is true for affiliates, but it's also true for other persons who may be involved in it. I think it's very similar from the standpoint whenever you're in a financial institution and you're outsourcing a service to a third party, the regulators are going to want to examine that third party just like they would examine you and their performance of that service as if you were performing the service for yourself. So I think that's the way I would think about it. And making available may mean providing access to their systems, just like the third-party service provider would provide to the NYDFS if they were doing processing or some maintaining of information of yours on their systems, in fact. So I think that's a broad read. but I think that's generally how the DFS reads that provision and how they think about it in the context of financial services regulation and third-party service providers and third-party vendor risk management.
Thanks, Jeff. And a couple of questions have come in about the date that these proposed rules went out. That was July 29th, I think we covered. But Jeff, one question that came in is just a little precision on the effective date. So it says, what are the new requirements? When are the new requirements expected to take effect? Day one, or will there be a buffer period?
Yeah, so I think how the process will play out is this is a pre-proposal. So there'll be a proposed rule that will come out next. We would expect that would sometime later this year. Then that proposed rule, they'll get comments on it. Then they'll finalize the proposed rule. The final rule is probably going to come out sometime next year, maybe first or second quarter next year, probably. And then after that, you're looking at the phase-in periods that are kind of indicated in the pre-proposal. So there would be a 180-day phase-in period. So if it was finalized on July 1st, you would have until the end of next year to implement all those provisions that aren't otherwise subject to a different period of effectiveness. So the 30-day effectiveness, for example, for giving cybersecurity event notices would take effect on August 1st. And then a year later, on July 1st of the 2024, that's when MFA, access privileges, and the endpoint provisions for the Class A companies would all take effect. But the other stuff basically would have 180 days. So from the date it's final and it appears in the state register. So there's still a time period out there. Again, because of some of the technical fixes and even from some of the asset inventory requirements, I do think that folks have to start thinking about either allocating some resources, allocating time, money, and resources, and how they're going to go out implementing it, because it's going to come pretty quickly.
Jeff, one other question that came in that was interesting. What now, because of the states that have adopted the NAIC model, cybersecurity regulation, do you expect them to follow the New York DFS and now amend the NAIC model? Thoughts?
It's an interesting question, and we've been thinking about this in terms of the FTC safeguarding rule, which obviously comes effective in December, because the safeguarding rule is largely patterned off of the NYDFS cybersecurity rule. It's a little different in the sense it doesn't require a certification or things of that nature. But at some point, I think there has to be almost the lowest common denominator approach. So to the extent that New York imposes requirements that go beyond the NAIC or they go beyond the FTC safeguarding rule, it's almost as if everybody's going to have to comply with the New York rule, whether those other rules are modified or changed, because I just don't think it's possible, given systems constraints and things like that, to adhere to different rules. So the NYDFS, in my mind, becomes the lowest common denominator approach, whether or not the NAIC model is amended or the states go back and amend their own laws. But it'd be interesting to see what they do, in fact, and states that subsequently modify it, whether they'll have some of the elements that the New York rule has in it now.
You know, it's interesting when you're talking about this, another question came in, and I think you talked about this at the beginning of the presentation, but the point is several of the slides mentioned the requirements being on institutions. What is an institution is used there? Are all covered entities considered institutions? And I think you talked about that at the beginning about the Class A, et cetera.
Yeah, that's a good point. We think of everybody who's covered as a financial institution, but technically the rule applies to covered entities, but that covered entities are obviously banks, insurance companies, anybody who's licensed by the DFS, mortgage companies, mortgage brokers, sales finance companies, money transmitters, all of those folks are covered entities. The only real distinction, I think, in the rules is how they're treating these Class A companies. And the Class A companies, by the way, cut across all different industries, right? So it could be insurance companies, it could be banks. You just have to hit those thresholds in there, and that's how you get treated as a Class A company. But for purposes of the regulation, really what we're talking about are covered entities, and covered entities, sometimes we use it synonymously with financial institutions, but it really means covered entities, and financial institutions are interchangeable with the exception of the Class A companies, which is a new class of entities and how they're treated differently under the regulation.
One other question I thought was interesting that came in through the chat here, Jeff. You were talking about the multi-factor authentication and the mobile phone not being a sufficient level, and someone was asking, what about external SaaS applications? Is IP address restrictions are IP address restrictions acceptable of a second factor?
I think they could be. Again, I have to go and look. I mean, this is a number of these questions have been coming up in the safeguarding rule as well. How explicit the rules are and what they do cover. But I think that's a very good question, something to kind of keep in mind, because it's generally a pretty reliable indicator of where somebody's located. Although, again, people do move around, and it may be that I'm traveling and that's why I'm getting a different, ping this time. So that's something to keep in mind, though.
Great. Well, I think that unless we have any other questions, I do see something just popped up in the chat. Sure. Someone asked, but in a large organization where we have smaller divisions who also hold licensure, does each still need its own policy, even though the divisions all rely on the cybersecurity of the large organization and are on the large org's system?
I still think it's certainly acceptable to flow down policies. I mean, if you think about it in the banking world, right? Policies adopted at the bank holding company level flow down to the bank, they flow down to the broker dealer, they flow down to the insurance company. So I don't think it's unreasonable to have a top of the house policy that flows down, especially if you're using common systems and common cybersecurity defenses. It would seem as though you should have a similar policy. So you're not precluded from flowing them down. It may just be that if there's a system that's common or shared service, that might be subject to DFS regulation, even though one of the entities may not be subject to the DFS regulation. And that goes back to the whole cybersecurity policy of an affiliate. But that doesn't mean you can't do it. It just may trigger some additional examination creep, as I like to think of it.
Yeah, I think that's a really great point. And in the broader context, looking at the current environment in terms of accountability with the recent convictions out there, et cetera, whistleblowers and so forth, this is really important to be thinking about, if in a flow down structure, really thinking about everybody in the chain who could have that accountability layer brought up at the senior management level or board level. So with that, I think we are just 1 minute. We're going to be able to give everyone 1 minute back. Any other questions, Jeff? Any last comments?
No, I think we appreciate everybody tuning in. Obviously, this is just one part of our Cybersecurity Awareness Month. A lot of other programming. You'll see Dominique and others again and again. So we encourage you to tune in.
Thank you so much.